Good morning and good afternoon, everyone. Thank you so much for attending our webinar today on employment law during the COVID-19 pandemic. We at Chugh LLP are proud to co-host this event with Delaney Insurance. My name is Chugh. I'm a partner and attorney with Chugh LLP in our Atlanta, Georgia office. So we are a full-service legal accounting and immigration practice headquartered in Cerritos, California, with 8 offices across the U.S. We just recently, at the end of 2020, opened in Washington State and Houston, Texas. I'm pleased to welcome Ashley Ingram from Delaney Insurance to our webinar today. Ashley Ingram is a Senior Vice President of the Health and Benefits Department at Delaney. She's a licensed property, casualty, life, and disability agent who specializes in small and large group and individual health benefits, covered California and worksite ancillary benefits. And since joining Delaney Insurance in 2004, Ashley has completed comprehensive insurance training in designing solutions for people, families, small and large businesses. Ashley, the floor is yours if you'd like to say a few words.
Thank you so much. That was quite the introduction. I appreciate that. Thank you. He had mentioned, Jamin mentioned that my name is Ashley Ingram, as Senior Vice President and Head of the Health and Benefits Department with Delaney Insurance Agency. I've been here for 15 years, and we're a property casualty and health and benefits agency. We serve the Inland Empire and surrounding communities for over 40 years. And we're excited and privileged to have collaborated with Chugh's law firm to bring this important and current employment law information webinar to you. We just look forward to bringing you more webinars like this with timely and valuable topics. So thank you, enjoy, and I'm going to hand it back to you.
Thank you so much, Ashley. Really appreciate it. So today's topic, employers have a complicated web of regulations to navigate during the pandemic. Today, our employment law experts will cover the FAQs related to the pandemic, including return to work plans, wage and hour issues, vaccine mandates, and since a lot of our attendees are based in California or from California, we're going to cover California workplace safety requirements as well. So our legal panel will address these topics, and that'll help the employers manage their legal compliance concerns. If at any time, if you have a question during the presentation today, please enter them into the Q&A chat box that's there on the top right, I believe. So let me introduce the great panel of attorneys that we have. We've got Nishita Patel, a partner and attorney from the Los Angeles office. Varduhi Danielian and Min Luong, both attorneys from the LA office as well, and Gurshan Chadha from our Santa Clara office. So let's dive into it now. So Gurshan, if you could start, please. And so what should employers keep in mind as they begin the return to work planning process?
Yes, thank you, Jamin. Beginning to return to work, employers should plan for how and when employees should return to work, and create an organized and controlled approach. All employees, if they return at the same day at the same time, could overwhelm the employer and possibly be unsafe for the employer. So now I'll walk you through a few safety measures that you might want to include in your return to work process. The first is phasing in employees returning to work. You could use seniority or other non-discriminatory factors for selection of who should return to work first. Consider adopting a work share program or sub-plan if bringing employees back on a reduced schedule. Determine schedule changes to provide the greatest protection to workers. Also implement an employee health screening procedure. Develop an exposure response plan that addresses isolation, containment, and contact tracing procedures. Also ensure a program that describes a stay-at-home requirement and exposure communications to affected staff. Provide personal protective equipment such as masks, gloves, face shields, and personal hand sanitizer. There should also be a detailing cleaning procedure and a procuring of ongoing supplies to ensure that all the cleaning procedures are met. Also implement a workforce vaccination strategy. Establish a physical distancing measures within the workplace. You could do this by staggering shifts and lunch break or rest breaks, rotating weeks in the office and working remotely, moving workstations to increase separation distance, implementing one-way traffic patterns through workplace. You could also restrict business travels and define customer and or visitor contact protocols, such as directing customer traffic through workplace, limiting the number of customers in any area at one time, no handshakes, greetings, and remaining 6 feet apart, using video or telephone conferencing instead of in-person client meetings, and providing contactless delivery or pickup. You could also create a plan for employees in high-risk categories for infection to return to work. Consider allowing them to work from home or remain on leave until they feel comfortable, and also determine increased measures to protect them while working on site, including isolated workstations, additional PPEs, or fewer days in the office. Furthermore, notify the state employment agency for employees recalled to work. This is a state requirement and will help save on unemployment taxes for those who choose not to return to work. Also, lastly, you want to determine how to handle employees who are unable or unwilling to return to work due to an ongoing risk of COVID-19.
That was helpful. Thank you, Krishan. Now, many of the employers will find that they must develop a new workplace policy since they are bringing their employees back into the office. So what are some of the policy changes that organizations should consider?
Yes, as you guys know, it's no longer business as usual, and employees will need to update or create new policies to reflect the new normal. Some of the examples include paid leave policies adjusted to reflect regulatory requirements and actual business needs, attendance policies relaxed to encourage sick employees to stay home, time off request procedures clarified to indicate when time off can be required by the employer should sick employees need to be sent home, flexible scheduling options implemented allowing for compressed work weeks and flexible start and stop times, meal and rest breaks policies adjusted to staggered times and process implemented to encourage physical distancing, travel policies updated to reflect essential versus non-essential travel and the impact of domestic or global travel restrictions, telecommunicating policies detailed to reflect the type of work that is able to be done remotely and the procedures for requesting telework. And lastly, information technology policies revised to reflect remote work hardware, software, and support.
Great, thank you. So as I understand it, California law AB 685 requires employers to fulfill certain communication requirements when there's a COVID exposure in the workplace. Krishan, can you tell us more about this law, please?
Yes, so the AB 685 requires that employers take prompt action in response to COVID-19 incidents. Employers must provide written notice to all employees who may have been exposed at a work site. The required notice must be provided within 1 business day of the employer receiving notice that an individual who either tested positive for COVID-19 or is subject to a specific isolation order was in the workplace. The notice must state that the employee may have been exposed to COVID-19, provide information about benefits which the individual may be entitled to under federal, state, or local law, including workers' compensation, paid sick leave, and anti-retaliation and anti-discrimination protections, and provide information about the disinfection and safety plans that the employer plans to implement and complete as per CDC. The notice must be distributed in a manner normally used to communicate employment-related information to employees and shall be in English and the language understood by a majority of employees. The name of the individual who was potentially infected should not be disclosed to the rest of the employees. AB 685 also requires that employers provide notice to their local health department in situation of an outbreak or major outbreak within 48 hours of learning 3 or more COVID cases that have occurred within a 14-day period at a workplace, or 20 or more COVID cases that may have occurred in a 30-day period in a workplace.
Great, thanks, Krishan. And there are some emergency regulations put out by Cal OSHA as well. So Krishan, if you could tell us about this policy for employers as well.
Sure. So effective November 30th, 2020, Cal OSHA requires almost every employer in California to implement a site-specific written COVID-19 prevention plan. This will include Employers will be asked to direct employers to act proactively per COVID-19 exposure to prevent exposure, including through mandatory assessments of prevention systems and plans. Significantly, the OSHA regulations require that employers offer free COVID-19 testing during work hours. Employers must offer employees who have been potentially exposed to COVID-19 in the workplace COVID-19 testing at no cost and during work hours. If an outbreak occurs, the employer must provide the testing to all employees at the workplace except those not present during the 14-day period. These same employees must be tested 1 week after the first test and retested weekly until the outbreak has ended. If a major outbreak occurs, they must be twice weekly tested. Twice weekly testing must be offered to all employees who remain in the work site during the 30-day period.
Great. Thank you, Gurshan. I appreciate that. And staying with California specific law, there's another SB 1159 that makes COVID-19 a workplace injury that wasn't the case before. So now it might be eligible for workers' compensation. So Verduhi, what new obligations does SB 1159 create for employers?
Thank you, Jamin. Hi, everyone. Thank you, Gurshan. Yes, Jamin, the California SB 1159 law was passed, I think, in September 2020, and that makes COVID-19 as a workplace injury, and therefore employees may qualify for workers' compensation. And the assumption is that an employee contracted COVID at work. Of course, employers can rebut that assumption by bringing in policies, some type of evidence that they actually did take safety measures in the office. But the assumption, again, is that the employee contracted COVID at work. So which workers are covered? There are 3 categories of workers that are covered under this law. The first category is all workers who worked outside of their homes between March 19, 2020 and July 5, 2020. And had a confirmed COVID case and worked at their place of employment within the previous 14 days. The second category of employees is essential workers. That could be firefighters, that could be medical providers, certain healthcare workers. And the third category is workers that meet all 3 conditions. First condition is the day on which the employee performed labor was on or after July 6, 2020. And the employee, again, has a confirmed COVID positive illness. The employer has 5 or more employees, and the third condition is that the employee tests positive during an outbreak. Now, when this happens, the employer has to determine whether an outbreak has occurred or not. An outbreak has occurred if within the previous 14 calendar days, one of the following conditions is met. First, one of the conditions is 4 employees test positive COVID-19 in a workplace of 100 employees or fewer, or 4% of employees test positive for COVID-19 in the workplace in a workplace where employer has more than 100 people. And then third is if the workplace is ordered to close down by a government agency due to the risk of COVID-19. So when outbreak happened, employers have 45 days after an employee files a claim. Employers have 45 days to determine whether an outbreak has occurred or not. If they actually find out that the outbreak has occurred, they have additional 45 days to deny or to accept the claim. California employers, according to this law, also have additional reporting requirements now. Once they learn that an employee has COVID-19, or they should have reasonably known that the employee has contracted COVID-19, they should report that case to their claims administration within 3 days, or they may face penalties of up to $10,000. Back to you, Jamin.
Thank you, Verduhi. That's going to be interesting to see the litigation that comes out of that new law.
Right.
So now, what anti-discrimination laws should employers be aware of related to COVID-19 and returning to work?
Yeah, so under Americans with Disabilities Act and the Fair Employment and Housing Act, we already know that covered employers are required to engage in a dialogue with an employee who has a disability and to reasonably accommodate that disability, unless that's going to create undue hardship for an employer. So under the Americans with Disabilities Act covers employers that have 15 or more employees, And FEHA, the Fair Employment and Housing Act, covers employers that have 5 or more employees. So, of course, COVID is not an exception. It also can constitute as a disability. So if an employee has a prolonged case of COVID-19 illness and has a doctor's note describing the need for an accommodation, the company should see if it can accommodate the worker. Of course, again, we are speaking about reasonable accommodation, but employers should also not want to see any future potential disability lawsuits against them, right? So, and then some employees who haven't tested positive for COVID, they can still consider having a disability if they have some sort of underlying condition. For example, it could be diabetes or high blood pressure, which makes them more vulnerable to COVID-19. And in case they contract COVID-19, they will have a severe condition. So if an employee with a diabetes comes to an employer and requests for accommodation, for example, be telecommuting or working on alternate schedule, the employer should actually try to accommodate that request, given that the employee has some sort of medical condition. And the reasonable accommodation may include a temporary leave of absence. It could be working on an alternate schedule, telecommuting, or it could be modifications to the work duties, workspaces. So yeah, and or everything, all of this combined. This was all about anti-discrimination, Jamin.
Thank you for doing. Yeah, I mean, changes to work schedules also going to include remote work as well, and so that's going to be an important option for many employers. I know that we did that for some time, and we're back in now for the most part. And so, what are some legal compliance concerns that employers should bear in mind for some of the remote work arrangements we're doing?
So this is a good time that employers should try and consider whether they want to still continue working remote or going back to the office with all the advantages and disadvantages of either type of work. Some of the things that employers at this point should consider is first, of course, if they want to go back to the office or work remotely. Second, if they want to do it part-time, maybe part-time remote, part-time in the office, like we do currently, right? It could be also responding to certain employees' requests, because even if the employer decided that everyone is going back to the office, there may be some employees that will reach out and request to work from home, and this could be even a long time arrangement, right? So regardless if employees work from home or from the office, we should always remember that especially non-exempt employee, there are certain requirements, legal requirements for non-exempt employees. And most importantly, that employers should have a journal, a ledger, or some sort of software for these employees to enter their hours, because that's a requirement. They need to enter their hours, their meal and rest breaks, their overtime hours. If the employers do not do that, I can promise they will see some wage and hour lawsuits coming their way. Employers should consider providing necessary items to their employees. That could be computers, that could be phones. They should also reimburse employees for certain business expenses that are necessary and reasonable. Such expenses could include internet, phone charges, computer, notebooks, pens, etc. And one of the most important things that I think Grushan also talked about, the policy, it's data security. Especially if employees work from home, there is this data security concern because they are connecting to the network from all the different IPs, to all the different internet connections, right? And that can be a concern for a privacy issue and for also software security. So if employer knows that there are employees that deal with certain sensitive data, employers should definitely try to use either encryption or some software security to block, maybe even to block access to certain type of information for certain employees to make sure that the safety and the data security is is provided. They may want to train employees to be able to handle data properly, even if they are working remotely. They could even consider maybe hiring an outside trainer who would come and do training. They could record that training and then they could reuse it for training in the future, training other employees. And most importantly, again, they should document it. I can't say it enough. This is very important. They should document the safety, the security policy. They can make it a part of the employee handbook, but they should definitely have it because that would help them in the future.
Thanks for doing that. That's helpful. So let's switch gears a little bit and talk about the paid employee leave. And so, Verdui, if you could tell us about what supplemental paid sick leave California employers need to provide to their employees now in 2021, and the eligibility of those employees, please?
Yeah, sure. Thank you. So COVID-19 supplemental paid sick leave, this is a new law that was passed again, I think in March 2021. And the sick leave starts on March 29, 2021, started actually, and applies to all employees with 26 or more, employers with 26 or more employees. It provides up to 60 hours of supplemental paid sick leave. And this is apart from any other supplemental paid sick leave that employees could use due to COVID. And most importantly, this was enacted on March 29, 2021. This is retroactive in its force, so it applies to January, goes back to January 1st, 2021, and ends on September 30th, 2021. But we do not know, maybe it will get extended. We have to keep our eyes out for it. So people who are unable to attend work or telework due to one of the following reasons are actually eligible for this leave. First is if, let's say, an employee cares for herself or himself because that employee either has COVID symptoms or has to isolate or quarantine as requested by a medical professional, or actually has already a positive COVID case. Second instance is that an employee cares for a family member. In case that family member has to quarantine or isolate, or that family member has COVID positive case, or they have to take care of a child whose childcare facility is closed down due to COVID. And the third instance is the vaccine-related stay, where employee either has to make an appointment to go and get a vaccination, or employee suffers some sort of side effects due to vaccination, so they are still eligible for this sick leave. And it is very important to remember that this leave, it does not apply to independent contractors. It applies only to employees. I will recommend employers to watch out here, because in case they do have misclassified independent contractors, misclassified employees, these independent contractors do actually qualify for this leave. So that could again be a potential lawsuit for the employers. And there are certain pay requirements according to this law. For each hour of 2021 COVID-19 supplemental paid sick leave, a non-exempt covered employee is entitled to receive, and the employee must be paid the highest of the following. It should be at least the state minimum wage. It should be at least the local minimum wage. It should be the employee's regular rate of pay for the work week in which the leave is taken. And an employer is not required to pay more than $511 per day, $511 per day, or $5,110 in the aggregate to a covered employee for this supplemental paid sick leave. But of course, the employees can use other type of sick leave that they qualify for in case they, the cap is reached. This was all about supplemental paid sick leave, Jamin. Thank you.
Thank you so much for Dewey. I remember when we did a prior webinar on the FFCRA, we talked about that law that came into play in March, April last year. Right. And so the California law seems kind of on par with that, adding the vaccination mandates there as well. So thank you for that. That's correct.
Yes.
Yeah, thank you for that. It was very helpful.
Okay.
So on the federal level, as mentioned, the Families First Coronavirus Response Act, the FFCRA, there are some tax incentives to employers that offer paid leave through that program. So Nishita, if you could please talk to us about that leave and the tax credits, please. Nishita, you might be on mute.
Thank you, Jamin. I'm sorry, I was on mute. Thank you, Varduhi, as well. As Varduhi had mentioned, the FFCRA, the Family First Coronavirus Response Act that expired in December 31, 2020, is now extended till September 30, 2021. And as of January 1, 2021, the employer's obligation to provide this FFCRA leave has become optional. Now, what does that mean? That means that the covered employers are not required to participate in the FFCRA, but if they did, they will continue to receive tax credits for the payments made to the employees on the leave for the covered reasons. Now, Vardi already went over the covered reasons. that means that if the employee will get can receive 80 hours of paid sick leave starting April 1, 2021. This means that if the employee has previously taken those 80 hours, now it will reset the 80-hour limit from April 1, 2021. The employers will also receive a payroll credit for the 100% of the qualifying wage for the FFCRA leave from April 1, 2021 till September 30, 2021, as long as the FFCRA leave was provided in a non-discriminatory manner. There is an additional notice requirement that the employer is required. That is, the employer must provide notice of the amount of the supplemental leave available to the employee on an employee's wage statement or on a separate writing. An employer must also post the notice in its workplace regarding this supplemental leave.
Thank you, Nishita. I'm sure that's going to create some wage and hour issues down the line. So curious to see what happens there as well. But perhaps you can talk to us about some of the wage and hour issues that California employers may need to address due to the pandemic.
Yes, sure. We have seen several wage and hour issues that have come up, including, compensation time for off-the-clock work. The off-the-clock work is defined in California is the wage and hour law, is that the work that an employee does without pay. Now, specifically as it relates to the time spent putting on and off protective equipment, hand washing, temperature checks, etc. This is very fact-dependent analysis. The courts have determined that it should be compensated as long as such activity benefits the employer. It is undertaken for the performance of the principal activity and is intended to protect the employee from the unusual workplace danger. The second query we had is on the hazard pay. Now, hazard pay is not a federal or state law mandate. It does not. The federal and state law do not require the hazard pay. It only requires the employers to comply with the minimum wage requirement and applicable overtime compensation. However, many cities and counties have passed ordinances to force the employers of certain workers like grocery workers, drugstore workers, and some frontline workers to provide additional pay in the range of $3 to $5 to its employees. Next, we have also have queries about the salary cuts. Employers can cut the salaries of the employees to save on cost. However, they should provide adequate notice to the employees. The salary reduction cannot be retroactive, and it cannot be done on a discriminatory manner. The employer should be cautioned about reducing the compensation of the exempt employees. It should not be below the minimum salary threshold for the exemption. Otherwise, it will be the exempt employees can be reclassified to a non-exempt employee, and in which case the employers will have additional obligations relating to maintaining the time record, as well as paying the overtime compensation, offering the meal and rest breaks, etc. Next, the employer can also reduce the cost by furloughing the employees or terminating them. The furlough is a temporary leave of absence where the employee is expected to return to work. Termination is there is no guarantee where the employee will get his or her job back. In both cases, the employee will qualify for the additional unemployment benefits through the American Rescue Plan Act and other policies, including the federal unemployment benefits of $300 per week, extended through September 6, 2021, in addition to the state unemployment benefits and the pandemic unemployment assistance, etc. The ARPA, that is the American Rescue Plan Act, which became effective on March 11, 2021, provides 100% subsidy for the COBRA premium from April 1, 2021 till September 30, 2021. Now, who is eligible for such subsidy? An individual who is eligible for the COBRA premium subsidy if he or she lost coverage due to reduction in hours or involuntary termination of employment. Employer must treat the assistance eligible individual who have COBRA coverage during the 6-month subsidy period as having aid premium in full. The ARPA subsidy applies to the involuntary termination and is limited to the people who had specific qualifying event under the existing COBRA laws. And that means that the person who resigns or is terminated for gross misconduct will not be eligible for the ARPA subsidy. The former employees who had COBRA coverage in effect on April 1, 2021 will be deemed to have paid their premium in full from April 1, 2021 till September 30, 2021. The former employees who did not elect COBRA or who had elected and stopped paying premium will have 60 days following the issuance of the new COBRA notice to elect to receive the subsidized coverage. The subsidy would end on September 30, 2021 or earlier if the individual becomes eligible for other group health plan coverage. The ARPA also have the notice requirements, which requires the group health plan or the employer to provide notice by May 21, 2021 to the assistant eligible individuals whose involuntary termination or reduction in hours occurred before April 1, 2021. The notice should be provided separately or by using the revised COBRA election notice and provide additional information regarding the new subsidy and the explanation about the election period. The individual who received the subsidy must be notified of the subsidy expiration between 45 and 15 days before it expires. The notice must identify the date the subsidy expires and must state the individual may be eligible for continued COBRA unsubsidized COBRA coverage. No expiration notice is required when the subsidy expires due to the individual's eligibility for other coverage. Now, to fund this new obligation under the ARPA subsidy, the employers will be eligible for 100% credit against the employer's quarterly payroll taxes. And if their Medicare tax credit is less than the value of the credit is refundable when the employer submits its quarterly tax return, that is the Form 941, so that the employer will be eligible for the full value of the credit. Employer will not get the credit for the COBRA premium paid for someone who is not an assistant eligible individual. If the assistant eligible individual inadvertently paid the premium from April 1 through September 30, 2021, the employer should refund such premium within 60 days. Now, some state laws also have imposed their own COBRA coverage requirements beyond the limits of the federal COBRA. For example, the California requires COBRA for the terminated employee with no qualifying conditions for a period of 36 months, in which case the federal subsidy applies for those who have received COBRA coverage beyond 18 months, but the subsidy will expire on September 30, 2021. Back to you, Jamin.
Thank you, Nishita. That's a lot of important information and definitely trending for COBRA coverage and what the employer's obligations are in that time period. So as of last week, the latest numbers that I saw, about 45% of the country got their first vaccine dose, and about a third of the country has both doses. So many employers are now considering whether it's legal to ask their employees for proof of their vaccine status. So Nishita, can you offer some insight into that question, please?
Sure. The EEOC has indicated in its recent guidance that it is generally permissible for the employer to ask whether the employee about the vaccination status. However, as long as the question calls for a yes or no answer, it is not likely to elicit any information regarding to the employee's medical information. Otherwise, it would invoke the federal and state disability laws. Next question that can come about is the employer is asking for the proof of vaccination. The employer can ask the employee about the proof of vaccination only as to the source and the date. And in order to avoid any legal issues, the employer should inform the employee to not provide any medical information. Anything further than this, any question, for example, asking the employees why the employee did not get vaccinated, employers should be cautioned on asking those questions, because that can lead to for the employee to elicit medical information. So unless and until if it is job related and consistent with the business necessity, the employer should not ask the employee as to why they have not gotten the vaccination. Also, this next question is about how the vaccination process went. The employer should not ask that question either, because such type of question would lead to eliciting the medical information. Back to you, Jamin.
Thank you, Nishita. Yeah, certainly there's a fine line between asking for that information and then diving too deep into some medical history. So thank you for that insight. Really appreciate it.
Sure.
So now what about a workplace vaccine requirement? Switching over to you, Min, is that legal in California?
Hi, Jamin. Thank you. Yes. Legally, employers can require their employees to get vaccinated. Employers will need to prove that it's a legitimate job requirement. The most common examples are nurses and healthcare workers. And the employer needs to accommodate or make accommodations to those employees who cannot take the vaccine due to a disability, medical reasons, or a religious reason. These type of reasons are protected under the Civil Rights Act. Therefore, it would be an exception to the mandatory vaccination rule, as long as it doesn't require significant difficulty or expenses to the employer. It's called the undue hardship rule. Employers looking to hire new employees can ask applicants if they are vaccinated, and that can be a hiring standard as long as they're holding their current employees to the same standard. An employer can request proof of the vaccination, but should not ask why if the employer says that he or she hasn't gotten it yet, because this, again, could accidentally lead to violation of the American with Disability Act. It's important to remember that proof of the vaccination cannot be required to have any other medical information aside from the actual vaccination evidence. So you can ask for the vaccination card, which just lists your name and the date that you got the vaccine. Shouldn't ask for medical records. In California, if it's mandatory, if vaccination is mandatory, the time taken to get it is compensated and any cost associated needs to be reimbursed. Additionally, employers cannot harass or discriminate any current or potential employees on any medical basis that's protected, disability, medical reason, religious reasons, and they cannot discriminate against an employees for requesting accommodation. Lastly, even if the vaccine are mandatory and everyone in the office has gotten it, it's still advisable to keep up with COVID-19 precaution, such as wearing a mask and social distancing. Thank you.
Thank you, Min. Vert Doohy talked earlier about some reasonable accommodations, and you did a moment ago as well. So the employers that decide to mandate the vaccine, they'll need to make those reasonable accommodations for folks that who cannot take the vaccine, for example. Min, what are some of those reasonable accommodations that employers should consider?
Yes. So some employees may have a disability or medical reason or a religious situation that prevents them from taking the vaccine. In these cases, the employee may request reasonable accommodation for their particular situation, and the employer must provide these. Reasonable accommodations are accommodations such as working remotely or infection control procedure, such as mandating mandatory masks, gloves, or social distancing. Reasonable accommodation in the workplace are required as an option for all employees as long as it doesn't cause an undue hardship on the employer. This means that if the accommodation doesn't require significant difficulty or expenses to incorporate, then they should do it. When deciding if an accommodation poses an undue hardship on the employer, employers should consider the type of accommodation as well as what it could cost to implement. It should be compared to the type of work the employee does and the employer's current financial resources. It's justified if an employee cannot accommodate an employee if what is needed cannot be provided by the employer. Thank you.
Thank you, Min. And then the employers that require their workers to get the COVID-19 vaccine should implement some sort of compliance tracking system or procedure. And Min, if you could talk to us about that and what that tracking system would entail.
Yes, thank you. So if an employer is making vaccination mandatory, it's highly recommended to incorporate a tracking system for the vaccine within the workplace. So this will help ensure employers to help put people at rest that it's safe to resume pre-COVID business activity. Including a tracking system would make it easy for employers to track which employees have been vaccinated, who is requesting accommodation, and other unique situation. It may be a burden for the administration team in charge of tracking, but employers are requiring vaccination. It's highly, highly recommended. If employers choose to have a voluntary vaccination system instead of a mandatory system, then tracking is not recommended. It would require self-reporting, but the information would be inconsistent and unreliable. In introducing a tracking system, employers need to be careful, again, in asking for vaccination proof to make sure that the employees is only sharing the information that's necessary just to prove whether or not they got the vaccine, and don't accidentally ask for medical information that may go against HIPAA rule. Thank you.
Thank you, Ben. So can you tell us a little bit about the benefits of the mandatory and voluntary vaccination policies?
Yes. There are drawbacks to both mandatory and voluntary vaccination program. So in a mandatory program, there will be likely pushback from employees, and there's cost with the tracking system. There will be an increased need for accommodation, and the employer should be sure that they provide it evenly across all employees. And if not, it may lead to discrimination claims. Employers must make decisions on how to write up the vaccination policy, how to collect them, and how to protect their employees' vaccination records. What are the risks for requiring versus not requiring vaccines are. For the voluntary program, the largest drawback is the lack of control that employers may have over their employees getting vaccinated. But there are positives to both programs. Mandatory programs are significantly more effective in getting employees vaccinated and can therefore allow companies to resume back to normal much faster. It can be motivating and relaxing for other employees to know that their coworkers are safe. It also lowers the possibility of becoming a high-risk environment. Voluntary programs are less likely to see retaliation and pushback from their employees. The Civil Rights Act accommodation won't apply when a vaccination is completely voluntary, and therefore allows the employer to ask more questions if employees want to volunteer information. Many employers have started using incentive for voluntary vaccination. we've seen companies provide gift cards or paid leave for their employees to get the vaccine, which is working well to motivate employees. Thank you.
Thanks, Min. Any other drawbacks of these policies that you think are relevant to this discussion?
Costs, maybe habit training, providing a handbook or procedure guidelines to avoid future lawsuits. Those are considerations.
Great, thank you so much, Min. That was really helpful. You know, we're open for any questions. If any of the attendees have any specific questions, feel free to add them on the chat here. We've got a couple that we can dive into. This is for Verduhi. Verduhi, can you tell us if can an employer require an employee to submit COVID-related documentation to qualify for the supplemental paid sick leave in California?
Thank you, Jamin. No, actually, it's interesting that an employee can qualify for up to 80 hours of supplemental paid sick leave, but an employer cannot require them to provide COVID-19 related documentation. And the reason for that is that the supplemental paid sick leave, a person can qualify for that leave even if they do not have COVID test, do not have a positive COVID test. So they have some sort of symptoms, or they just are required or are recommended by a medical professional to isolate. So no, the employer cannot require them to provide documentation. However, if an employer, let's say, has some kind of evidence that an employee is supposed to isolate and inform the employer that they are supposed to isolate, they didn't provide any documentation, but the employee is out in the park enjoying his time with the family, for example, then of course the employer can go and say, okay, this is what I have seen, can you please provide the documentation? Thank you, Jamie.
Thank you so much, Verduhi. I'm going to send this one to Gurshan. Who should the employers notify of their potential exposure to COVID-19 under the new AB 685 law that we discussed earlier?
Yeah, thanks, Jamin. So the law now clearly states that the employers must provide a written notice to all employees and the employees of subcontracted employees who were on the premise at the same work site as the person who was infectious with COVID-19 or who was subject to a COVID-19 related quarantine order. After becoming aware of the potential exposure because someone at the work site was infectious with COVID-19 or is ordered by a public health official to isolate due to COVID-19 concerns, employers must immediately, within 1 business day, provide a written notice to the employees and the employers of subcontracted employees.
Great, thank you, Gurshan. Next couple to Nishita, please. So Nishita, is hazard pay required in California?
California does not require hazard pay. It only requires the employers to pay the minimum wage as well as the applicable overtime compensation. However, there are cities and counties in California, they have passed ordinance to force the employers of the grocery stores, drug stores, and other frontline workers to provide additional pay in addition to what they have been already paying the employees. The range is between $3 and $5.
Okay, great. And I know you covered this in your presentation, but just at a high level, can you tell us how much of the paid leave offered to employees is covered by the FFCRA tax credit?
It is 100% of the paid leave provided to the employees between April 1, 2021 till September 30, 2021 would qualify as a tax credit, as long as the FFCRA leave was provided in a non-discriminatory manner.
Great. Thank you so much, Nishita. We've got a question here on the chat. It seems employers really have the burden of updating their employee handbooks. Yes, absolutely. It's certain that the employers have the burden of updating the handbooks whenever these policies come out. And you know, I can open up to any of the panelists on the call today, but specifically for California as well. So if they want to chime in for this particular question.
Yeah, Jamin, so I have seen my clients reaching out and requesting to update the policies because we have been seeing so many new laws and new requirements for employers. And as I mentioned, I think everyone mentioned during their presentation, we cannot, again, say it enough. It's very important to have everything documented. It is very recommended to have these policies in your handbook so employees do have access to the handbook, and then you also have an evidence that you did provide the employee handbook to your employees. So it is like a two-way street. It works both ways. It helps your employees to know what they are provided with, what they are secured with, but then also what the requirements are. But then it also helps you to then fight any future lawsuit you can face.
Yeah, absolutely agree, and that applies to, you know, COVID or non-COVID related matters as well. I think having a robust handbook is very important, just to make sure that the liability is diminished for the employer.
Yeah, I couldn't agree more.
Great. Min, the next one's for you. We talked about undue hardship a little bit, and so. How can a company prove that accommodating an employee would cause an undue hardship?
Yes. So an undue hardship is defined as an action requiring significant difficulty or expenses. While the determination of what constitutes an undue hardship is extremely fact-specific, the courts will use factors to and look at the nature and cost of the accommodation. They'll even look at the availability of tax credit and deduction and or outside funding, like what's available for the employer, the overall financial resources of the facilities involved in providing the reasonable accommodation, and the number of persons employed at the facility that affects all the accommodations on expense and resource, or the operation of the facilities, including the impact or other employees' ability to perform their duties. The overall resource of the overall entity, the size of the business with respect to the number of employees, the number, type, location of the covered facilities, the type of operations that the employer is engaging in, the compensation, the structure, the workforce. It's all very fact specific to see if the company has an undue hardship.
Great, thank you, Min. That's helpful. Back to Verduhi. We had talked about these previous webinars where we had discussed, and there were a lot of small businesses and small business owners that were on the call. And there might be today as well. And the federal law was a little bit vague in the very beginning about these small businesses. And so Verduhi, for example, if there's an employer with 5 employees in California, and let's say some more out of state, does the SB 1159 apply to them?
Yes, well, as long as they have 5 employees, that for sure applies. But the concern was that whether if let's say an employer has less than 5 employees, does still the employer required to follow the law? And the answer is yes. So even if let's say an employer has 2 employees in California and then 4 employees out of state, they still have to report any positive COVID test and the cases to the claims administrator, because it's up to the claims administrator then to decide whether an outbreak has occurred. It's not up to the employer to decide. And the claims administrator is going to collect all the information regarding where the case happened, the address, the date, and all of that, and then based on the collective data, decide whether an employer had an outbreak. So yes, thank you, Jamie.
Thank you, Verdui. We've got a couple minutes left, so if there are any other questions, feel free to add them on the chat. And while we're waiting for any of those final questions, I want to thank all the panelists today for taking time out to present. Specifically, Nishita, Gurshan, Verdui, Min, thank you so much for the great content, and to our entire wonderful marketing team for putting this on as well. And if you have any other further questions, our email addresses are here on the screen at the moment. And if you want to schedule a consultation, feel free to send us an email at info@chugh.com. You're welcome to reach out to one of us directly as well. We have monthly webinars that we put on each month, and with our wonderful partners like Delaney. Thank you again, Ashley, for joining us and helping us put this on as well. And so we have these webinars for COVID-19 resources for small businesses. Feel free to visit our website at www.chugh.com and to register for other upcoming webinars. And please join our YouTube channel at Chugh LLP for new business content. And thank you, everyone. Really appreciate you joining, and thank you for attending our webinar today.
Thank you, Jamin.
Thanks, everyone.
Thank you.
Thank you.
Thank you.